right, good morning. So we're going to get started with session one, Empowering Justice, the Opportunity for Law School Clinics in the Field of Preventive Legal Advocacy and Pre-Petition Representation. We have three panelists for this session this morning. Our first is Cary Bloodworth, Director of the Family Legal Advocacy and Supports Clinic at University of Wisconsin Law School. Also joining us from University of Wisconsin Law School is Jennifer Binkley, and she is the Director of the Family Court Clinic. And then we also have Rebecca Greening, lecturer and clinical instructor at Harvard Law School and the Wilmer Hale Legal Services Center Family Justice Clinic. And with that, I will turn it over to you all.
Good morning, everyone. We're going to confuse you all and go out of order. So I'm going to start. I'm Jennifer Binkley. I'm the director of the Family Court Clinic. And do we have our slides? There we go. Great. She's going to get that going. So we're going to, this is our first slide, just explaining what we already know. And I'm just going to go through this first slide, and then I'll pass things over to Cary, who's been spearheading this program. I work closely with Cary, but she does the lion's share of the effort with her clinic. But before there was Cary, there was me alone, and we were the Wisconsin Department. Just to let you know how we started our program, the Family Legal Advocacy and Supports Clinic. We were approached by the Wisconsin Department of Children and Families, the law school sort of generally, and I think there was then a focus on the Family Court Clinic, and I should say the law school clinics that provide civil legal services. So we are under an umbrella program called the Economic Justice Institute. And so there are other clinics that provide civil legal services, but the Department of Children and Families did identify family law as the greatest single need that those that were families that were in jeopardy of having child protective services actions had a need for. So we kind of kept narrowing, and we said, sure, or I said, sure, we take these cases, these sorts of cases. We could certainly have referrals from you, but we can only take on so much with the staffing we have, which is me and my law students. So, sure, send folks our way, but, we'll do what we can. And they said, well, and I said, if I had funding, we could hire somebody and potentially they could take on lots and lots more cases because we'd have double the capacity. And they said, well, we do have funding. We have all this money we need to use in a short period of time because it's money that came through COVID relief and stimulus funds through the federal government. It has to be used by 2026. So we said, oh, well, if we do have funding, that's great. So then we started, what would this be? What would it look like? What would the contract look like? The hiring process, again, working with two large bureaucracies, University of Wisconsin-Madison, which is part of the university systems here. Also the Department of Children and Families, which granted is another state organization, but also is distinct and different. So there were good things about working with another state agency, but there were also drawbacks. And frankly, Cary asked me a long time ago when she was working on some other project or presentation, why did they pick us? Why the law school? Why not legal action? Why not some other nonprofit? And I said, because it was easiest and fastest, because we are another state organization and they didn't have to open it up for bidding with private organizations. So frankly, I think that is a big part of it. But also we did have the expertise and the capacity to hire quickly, which we did. And so happy to have Cary on board. And she'll talk about the continuing challenges of having an end to our funding, because that money does need to be used up. And that continues to be sort of hanging over our heads, but we have had a lot of successes and super happy to have Cary come on board, because this, I have to say, getting this going and the funding and all the meetings was a huge amount of work, and she immediately took it all over to continue the contract negotiations that go on every year, as well as obviously running the clinic. So I will hand it over to her.
Morning, everyone. I'm going to talk about our model, our law clinic model. And it struck me when I'm done, Rebecca is going to talk about her law clinic model at Harvard. And she and I met on Monday. And aside from the fact that we're both housed as law clinics, law school clinics, we are very, very different programs. So I think this is kind of an interesting, you'll get to see two very different ways of doing a law clinic. And I think we're both going to talk about some of the opportunities that our models have, and then some of the challenges that they have as well. So as Jennifer mentioned, our clinic is a model, is a partnership between lots of different organizations. So we've got the Department of Children and Families. They are our funder. They also were doing a lot of data collection and analysis for us during our pilot. And they provide a lot of project management services and support. Then there's the Children's Court Improvement Project, which is an organization housed in under our state Supreme Court, and they essentially advocate for children's court improvement, as the title says. They provided a lot of strategic support at the beginning, and they've been very helpful in getting the word out to different system players about our clinic. Then the law school provides the law students who do the bulk of the legal work for clients. They provide the physical space. Our clinic is housed in the actual law school. And then, of course, they provide me, the clinical instructor, and the support that goes around that. The Sandra Rosenbaum School of Social Work at UW also provides 2 social work students to our program. And those social work students, they're master's level, and they are doing their field placement for their master's degree in our clinic. And so we have them for a full year as well. And they are able to provide non-legal social support services to our clients, which gives us the opportunity to provide really multidisciplinary, holistic support for people who come to us. And then at the bottom there, you see we have 4 county agencies that we work with. Those are all child welfare agencies, and they are our direct source of referrals. So all of our referrals come from one of those 4 counties, Jefferson, Dane, Sauk, and Rock. Probably nobody knows what those are if you're not from Wisconsin, but they're all kind of right around Madison. So we've got some primary objectives and intended outcomes that were identified at the beginning of the project based on some studies that DCF had done about needs. And so those are preventing potential removal of children from their home, keeping kids out of foster care, and then building support for upstream investment. And what that really is about is sort of promoting this idea that upstream investment is less expensive, less traumatic for families, and leads to better outcomes for children in particular. I want to add a couple of goals to these on the law school side of this, because this is a law clinic. We do balance our clients' needs against the educational needs of our students. So we do also have additional goals, right? We're trying to educate future attorneys. We're the flagship school university in our state. And so we are educating students, and we're hoping to educate the law students in a more holistic legal approach and a more sort of trauma-informed approach. And then for the social work students, they're really getting the opportunity to get an education in this more families first model, preventative model, rather than social work students who do their field placement in county CPS agencies. So we provide 3 basic levels of services. Our primary focus is family law, because that was what was identified by social workers as the primary need for families. And so most people who are referred to us are referred for family law issues. And when I say family law, I mean things like divorce, child support, custody and placement. And we also do guardianships, private juvenile guardianships. Most of our family law referrals are getting what we call service appointments, which are one-on-one appointment with a law student to go through forms to fill out for whatever issues they have, walking them through basic legal procedures, giving them information about the legal process. And then some of our family law referrals are receiving direct representation from us. And the way we select those is based a lot on capacity, timing. So because we have law students, it's hard for us to take, for example, right now, my students are on break. It'd be very hard for me to take on a direct representation case right now, but also on student capacity, complexity of the case. So there's a lot of factors that go into selecting those. And then for other cases, specifically non-family law referrals, we get referrals for housing issues, consumer law issues, employment. We try to refer those out to other organizations that can provide assistance. So we do warm handoffs where we're contacting the organization ahead of time and trying to directly connect the referral with a person in that organization. And we're really lucky, Jennifer mentioned we're part of a broader civil clinics program at the law school. And so we're really lucky to have clinics who can provide assistance. We can provide in-house referrals to some of the other clinics for a lot of the referrals that we get. And then all of our referrals have the opportunity to work with a social work student and receive social support services if they'd like to. So they can be receiving any of those legal sort of services and still be eligible to receive social support services. This is our clinic workflow. It just kind of shows you sort of how clients move through the process. I won't go into this too much, but it starts with a referral from a county CPS worker, and then the law students are the initial point of contact, and that's because our social work students are considered mandated reporters. And so we want to make sure that our law students are having an informed conversation with the referrals before the referrals agree or decide they want to work with one of our social work students. And if they do, those social work students then come in and are providing those supports as well. I have a few case examples I'll go through really quickly because I want to make sure we leave Rebecca all of her time. So the first, we just finished our first year. So these are two kind of cases we had in this past year. The first I'm going to refer to as Michael. That's obviously not his real name. He was referred to us for an uncontested guardianship and then help with some with Medicaid and food share. He had his long-term girlfriend had recently passed away. She had a child with another man who also had passed away many years before. And so we were trying to work with him to get guardianship of his essentially stepson. They weren't married, but it was he'd lived with the child for many years. And as we became more involved with him, we realized there were a lot more social support needs than we had initially kind of identified. And so we've worked with him for over half a year now, and we were able to eventually get him full guardianship, get him stable housing. We worked with him on an employment change. We've worked with him on child care, helping him get transportation, mental health services for him and for his stepson, as well as lots of benefit kind of stuff. So including survivor benefits, which were able to help financially secure the family. And then Shelby was referred to us for a post-judgment motion in family, paternity actions, and domestic violence stuff. Her ex-boyfriend, she had a restraining order against him. There was a long history of domestic abuse. He physically assaulted and very significantly injured their 3-month-old baby. And so she was referred to us. There were a lot of complicated legal needs. So we had a paternity action going for the baby, and we had a post-judgment family case going for their older child, as well as the restraining order issue. And then there were criminal charges that were pending at the time as well. And so we were successfully able to help her with those legal issues, as well as help her with things like food share, Medicare, childcare, and then procuring supplies for her, like diapers and clothes and things like that. Like I said, our model provides a lot of opportunities, but also a lot of challenges. So some of the opportunities with the way our program is structured is that because we're partnered with, quote, the system, right, system players, has created a lot of buy-in from decision makers and a lot of support within the system, which has been helpful. It's also provided us with a built-in source of referrals. So all of our referrals come from the CPS, the child welfare agencies. And so we don't have to kind of figure that part out. It was built into our model. It's also provided us a shared effort to fund the program long-term. So we're about 1.5 years in, and everybody's been working and is starting to work on looking at longer-term modes of funding. And the partnership with the social work schools has really allowed for us to have a multidisciplinary model where we're able to holistically support clients. And then some of the challenges we faced, the first is that our funding source and the contract that we have with the department based on our grant really limits what types of cases we can take. So we can't be adverse to the department or any county agency. So that means we can't do, for example, we can't represent in an investigation. If we're working with a family in a family law case and a CHIPS petition is filed, we can't represent the parent in the child welfare proceeding. And so that has been a challenge. It also has created some, it requires us to do a little bit more trust building with clients, because sometimes they do view us as part of the system. They're referred to us directly from CPS. And so even though one of our criteria is that the participation has to be voluntary, it can't be coercive on the part of the child welfare agency. We do still have to do a little bit of additional trust building in order to kind of overcome that piece of it. Our funding is short-term, so we are currently looking at long-term funding, and it's looking like it's probably going to be piecemeal if we're able to do it. So that kind of sucks. And then our current structure right now, our social work students are mandated reporters, which I do think is a bit of a hindrance towards a true collaborative effort to support clients. And so going forward, I'm kind of looking at ways to address that as well. And so with that, I'm going to turn it over to Rebecca to talk about her program at Harvard.
Awesome. Thank you so much, Cary and Jennifer. I'm going to attempt to screen share now. Wonderful. I hope everyone can see. I'm part of Harvard's clinical program. It's a massive clinical program. And the name of the center I work in is called the WilmerHale Legal Services Center. And our clinic is the Family Justice Clinic. The Legal Services Center is a very long-standing program of Harvard. It's been in different places, but since 1979. It was established by Cary Bloodworth, who's a legend in the clinical field and a mentor and leader to a lot of clinicians who are still in the work today, and his wife, Jean Charn, as well. And they established it really kind of in the model of the medical training field as a teaching law office. So kind of viewing it as a community triage center for legal issues where folks would come in and the students would learn by doing and through experiential learning. So it is very much embedded in the community. Folks know that we exist, where we have partnerships with many different community organizations to get cases. And we house 6 different clinics under one roof. So in that way, we kind of try to operate as a true community legal aid where we can make internal referrals to each other and make sure we can meet as many of the clients' needs as we have in-house. Harvard's clinical program comes in many different flavors, but we are one of the ones that is run on the traditional semester basis. So we're in the fall and the spring, a 12-week semester, which flies by. So upskilling the students and getting them ready to do work on cases in 12 weeks is, I'll talk about that later, but one of our challenges. The current program that we have in the family practice, which is where I work with my co-instructor, Mariana Yang, is mostly a medical legal partnership. That's what we've been doing for the past over 15 years with a large hospital system in Boston for their domestic violence, intimate partner violence intervention and support program. So those are the social workers who are embedded in the hospitals, community health settings, who are receiving referrals for social work support for folks with IPV situations. And then those folks who have identified family law legal needs, they get referrals over to us. So kind of in that milieu and those clients, we already have a lot of folks who have, in Massachusetts, it's called DCF, or our CPS is called DCF, similar to Wisconsin, the same. And so a lot of those folks experience DCF involvement already. So some of the cases that we take on for DCF specific representation come out of that referral relationship. And the family practice over time has really been responsive to community need. And that's what we see, what we're doing now in early defense, family defense, as being responsive to a gap in services that are available in the community for folks. In Massachusetts, folks do not get appointed counsel until there is a court case. And most of those are, precipitated by a removal, sometimes not, sometimes they're just the state is just seeking access or some other sort of protective concern. But for the most part, folks are facing a removal situation, and that's when they get their lawyer. So we're seeing a huge, vast array of involvement with the state child welfare authorities prior to any court case being filed. So all in the investigation phases, assessment phases, they're called action plans here. So service planning, service identification, service planning, all of that representation for folks who are indigent or poor goes without representation. Obviously, if people are involved with the system and are of means, they can hire private counsel to manage any one of those phases. So just a little bit more about kind of what we're facing in Massachusetts. Obviously, many of you are familiar with the ACLU Human Rights Watch report about racial disproportionality in the system and who is more impacted in our communities. And, you know, it's pretty startling statistics, as all of you I'm sure know, that over half of Black children in America will face a child welfare investigation before age 18. And just this past November, the Boston Globe had a big article about the racial disproportionality with respect to Latino children in Massachusetts. And they're more than twice as likely than white children to have an open case similar to Black children, but Latinos are even a little bit more overrepresented in Massachusetts than Black children. So clearly, in Boston in particular, in a very a place that has a very conflictual relationship with racial segregation, redlining, there's clearly intentionality to communities being under-resourced. Okay, framing our work. So I highly recommend for any of you considering doing a law clinic, the article by Julia Hernandez and Tarek Ismail, Radical Early Defense Against Family Policing. I really love their framing of the work and the opportunities that they present for this work. And this is one of the quotes I pulled from their article. Radical Early Defense is the representation of families at the earliest moment possible with the intention of restricting or eliminating the state's coercive encroachment into a family's life. And I just find that to be a really nice, succinct framing of the investigation phase representation. And the optimal goal really is to help people as soon as CPS or DCF here in Massachusetts enters their life. And so that really poses the question of, what does client-centered trauma-informed lawyering look like when representing parents in early stages against CPS? And through our practice already, representing survivors of intimate partner violence in family law matters, that's really what we emphasize with our students, is being client-centered and trauma-informed. And what does that look like when we're doing early family defense cases? And I think it presents a lot of opportunities for really unpacking what that looks like. How do you counsel? How do you advise? What do you counsel? What do you advise? All of these things are really important lawyering questions that we help our students navigate in these cases. So a little bit about what the work actually is. What do we do? So we call it early family defense because we want to be upfront about our orientation to the work. So we're representing folks in investigations, and then if those investigations result in Massachusetts, it's called supported finding, but substantiated, it's many terms across the country, we'll represent them in the administrative appeal. It's called a fair hearing appeal. We'll also do ongoing case advocacy. So if somebody has, has had an open case for years and wants to have it closed, or has some other kind of problematic involvement with the department that they don't have any support for, we'll kind of do a consultation, or we'll even enter into a representation agreement to actively kind of insert ourselves into the case as attorneys and help advocate against the agency for closure of the case. Know Your Rights has been a huge component of our work so far, because one of the main ways we are trying to get cases is through community outreach and community partnerships. So we work with mostly right now grassroots organizations that are impacted parent-led organizations. So these are folks who have experience with the system, whether it's they were in foster care themselves, they had an investigation, a filing on them, or they had their children removed and reunified. We try to do as much as we can, because they're really fledgling organizations trying to get off the ground, to partner and provide programming. Essentially, we do a Know Your Rights series, which we developed, and this was one part, if you're interested in doing this work with students, where the students really loved it, and it was a great way to teach them kind of the substantive law behind the work we do, because they had to then, you know, make presentations for the public in a very accessible way, to make sure people can actually obtain the information that we're trying to impart. And so part of our work is doing that, just kind of being in the community, developing these relationships, being able to take referrals from our community partners. And that includes, you know, the medical legal partnership we already have. And in addition to that, we're working to develop mandated reporter trainings. We're actually working with a pediatric residency program to be part of their training curriculum to unpack more about what mandated reporting means, what happens after you file a report, what does it look like in people's lives. And that's been a really exciting opportunity to go out and talk with a lot of folks who are mandated reporters about how they navigate their role as mandated reporters. Do they see themselves as you know, file and forget it, or as Joyce McMillan likes to say, you know, mandated supporters? And there's a huge spectrum, obviously, in between. So more about kind of what that looks like when we do community outreach. What we spend a lot of time doing is really just unpacking process for people. So this is like really traditional community legal education, where we take just like, this is what your support letter looks like. This is where it says you have a right to appeal. This is how you do the appeal. This is the definition of abuse. This is the definition of neglect. This is what's likely to happen at the next phase, or is going to happen at the next phase. Say there's an administrative appeal, and what does that actually mean? Who is the hearing officer? So it's really just defining a lot of terminology, unpacking a lot of process. And this presents its own challenges, because a lot of the folks who come to our presentations, you know, have had either longstanding involvement or active involvement with the agency, and some of them have their children removed. And so, you know, I'm saying, well, why aren't you talking to your lawyer about this? You have a court-appointed lawyer, and maybe they can't get in touch with their lawyer, or they don't feel comfortable talking to their lawyer. So it's been an interesting, since my background is in being a public defender representing parents, and in Massachusetts we do parents and children, you know, helping people navigate, okay, like even understanding how do you access your own court-appointed lawyer? What are some best practices for working with lawyers? So there's a lot of very nuanced conversations that come up, and part of the challenge in this phase of the work is really to, you know, toe the line with providing legal information and not providing legal advice, especially where somebody is represented by counsel. So that's a big tension that we talk with the students a lot about, and figure out like, okay, where is the line here? What are the boundaries we have to keep? And so those really promote a lot of good ethical conversations with students. And so I'm gonna, sorry, gotta have myself. I have one video from my student who just ended this past semester, just so you can hear a little bit from the student perspective. Her name is Jessica Wu, and she's a second year at Harvard.
My name is Jessica Wu, and I was in the Family Justice Clinic at Harvard Law School this past semester. To be honest, I didn't come into the clinic knowing much about Massachusetts family law, but thanks to the readings, guest speakers, and personal stories from our instructors, I left the clinic feeling much more equipped to discuss how the family policing system adversely impacts Massachusetts residents. For example, how appalling it is that many mandated reporters don't understand the deficiencies of institutions like DCF and report families without understanding the terrible effects that a report can have. This was something that I directly encountered through doing a fair hearing case myself. It did feel pretty daunting at first to take on the case, because it was the first time that students have done fair hearings, but I relied on the skills that I gained from past cases to do so. I started off by familiarizing myself with DCF policies and procedures. I spoke extensively with the client, her family, past legal team to get a full picture of the facts beyond the extremely biased versions found in the 51A and 51B reports. And of course, my clinical instructors were so helpful. Their vast lawyering knowledge and experience with DCF and knowing, you know, what's likely to work, what's likely to not work, helped immensely with preparing a case theory and just letting me know what to expect at the fair hearing. Our client was really happy with the way that the fair hearing went. I think she especially enjoyed the cross-examination and hearing me question the DCF employee who had given her so much grief. And while we don't know the outcome of the case yet, I'm glad that she was able to get representation and, most importantly, the chance to share her side of the story. It's also valuable to know that my experience will be used to further develop this practice area at the law school, and that the setbacks that I faced will be used to make fair hearing cases an even better experience for clients and students in the future. Throughout this experience and other cases I took on, a big takeaway was how important client skills are in this area of the law. Some aspects of family law, I think, how to fill out a financial statement, a child support guidelines worksheet, that gets easier after only a few cases. But learning each client's nuances, like whether a client is technologically savvy or not, or whether a client is chatty or hard to reach, and adjusting to fit their needs. This is something that was always a new and interesting challenge as the semester went on. Another takeaway was what a huge privilege it was for us to be entrusted with clients the way that we were. For example, I assumed Rebecca would be there for my first intake at the beginning of the semester, but she told me she had confidence I could do it myself. And this trust she had in me for this task and others carried me throughout the semester and has built my confidence for becoming a full-fledged lawyer. And lastly, my biggest takeaway was how important and impactful this work is, and that this is an area of law that I hope to stay involved with in the future.
So a little bit from our students, so you can see what they take away from the work. Just very quickly on our challenges and opportunities, because I want to leave time for questions. Last year we piloted the work, so we didn't have any sort of readings or doctrinal-ish work integrated into our seminar portion. So we have clinical work and then a seminar. So there's been a lot of building the plane while flying. We're doing the work we were piloting last year without having that fully integrated. This academic year, we've integrated, readings and substantive trainings as part of our seminar, which has made things a lot easier. But also, the second part of this is just finding space for everything. When you do a family law clinic, you're likely doing a million substantive areas, restraining orders, paternity, divorce. There's so many things that you have to train students on. And that loops back to only having 12 weeks. It's not a lot of time to get students, really up to the skills that you want them to have by the end. But I'm always amazed by the growth that they have. It's really incredible in that amount of time. And, one of the opportunities for us really is to expand our model. We obviously work in a medical legal partnership for the cases we get from our partners at Passageway, who are social workers, but they're outside of our organization. They are still mandated reporters. So while that's a benefit, we too would like to explore ways to bring in-house social work support and have that social worker be under our privilege and not a mandated reporter. And also peer support. I think that's really the gold standard model, is to have that, tri-part model where we have an attorney, peer support, and a social worker. And I'd love to be able to get funding to do that and move in that direction. If you're thinking, or your school is thinking about doing a clinic in this space, I think, one of the pain points is just making sure the instructors both have knowledge, because this is a very an area where you really need a lot of practice knowledge in order to be able to guide students through advising or through even understanding what's going on. And capacity, ability to take a lot of cases, similar to Cary and Jennifer, were, constrained by having students where we also have to make sure the clinical work, the work that we take on, kind of fits that ecosystem of the student need and the client need. And then the ability to train students. So like I said, it's amazing to see their growth, but it does take a lot of investment of time and resources, which, none of us ever have enough of. So thank you. I'm going to stop there so we can answer some questions, but I'm so happy to be here and presenting. And if you want to reach out to me about exploring this for your own law schools, I'm happy to chat with anyone.
Thanks so much, Rebecca. I'm going to, for all of the presenters, I'm going to run through some of the questions that did come in. And I think Cary, excuse me, Cary, I think this first question was with respect to your program, but if the referrals are coming from CPS, Does that become problematic in that it leaves it up to CPS to decide which families find out about your services? Do you have some thoughts on that?
Yeah. So yes, that's something that I thought about a lot really early on. And I do think it is. We've taken a few steps to sort of try to alleviate that. So we do a pretty thorough initial training of the social workers, the CPS workers, to try to explain what an appropriate referral might be, give them some information and guidance about the types of questions to ask to sort of understand whether there are legal issues that they might need assistance with. We also developed some written materials that we sent out to all the CPS agencies that we work with that they're able to reference. And our social work students last year helped us develop some sort of references and guidelines for that, which was really helpful. We also do ongoing communication with the counties. So every month I have a meeting, just me and the county agency supervisors. And I'm able to give them feedback about referrals we are receiving, and they're able to ask questions. That has been really helpful. So for example, last year we were getting what I thought were a lot of really inappropriate guardianship referrals. And so I was able to kind of address why I thought they were inappropriate with the county supervisors. We set some sort of guidelines around guardianships, and it has not been as big of an issue this year. And the other thing I'm doing is tracking data on my end. So we are tracking, for example, race and age and gender to try to just get a sense of where that is. And we're tracking it for our benefit too, sort of an internal check on which cases we're taking on for direct representation and which cases we're not. But I'm also sort of looking at it to make sure what we're getting is representative of the CPS, sort of what CPS is seeing as a whole, sort of check it on the like implicit bias front. But yes, I agree, it is. It is a challenge.
Thanks for that explanation, Cary. Let's see, we had another question come in. So someone was saying that they started trying to use the term, and I think this goes to both programs, but they started trying to use the term family defense and got a lot of pushback from the agency and some of the attorney GALs for kids. And so they were wondering if you had any ideas on kind of speaking that truth and still being able to collaborate, you know, when you're kind of taking those stances. Do you guys have any thoughts on that?
It's an intentional choice for us to use that language, just because I think one of the pain points that Cary was speaking to about kind of trust building with clients is really trying to help them understand that we do not work for the agency. And I think like people understand what a criminal defense attorney is, and that's a pretty well understood framework of like, this person doesn't work for the state, they work for me. And I think that that's why we have leaned into using that language. Obviously, like family preservation and other language, you know, also equally available to use and might be kind of a softer approach with the agency.
Hi, my name is Jessica Wu.
Oops, sorry, I don't know what happened. My student wanted to come back. So yeah, so I think like that's the reason we chose to do it. And I think like in explaining that as like the background of the reason, I think might be an in to get that language to be more familiarized and used. But I think it's just really for us to try to make sure we're framing it for the clients in the best way possible.
I just would add too, when we designed our program and decided what to call it, I think we started with like pre-petition legal clinic or something like that. And the agency, the representative from DCF said, we don't want to use that language because it sort of implies that there will be a petition, right? Like we're in here first, and then because they're like, we don't want that. We're trying to avoid that. So our language is very similar because advocacy to me also implies defense. But I think that it's interesting because defense implies, again, that there's going to be a conflict with, and our program is particularly to avoid that at all. Right. So we're pre-petition. And so we want advocacy to avoid, right, to divert. So I think that that's why our name is what it is. And it's just because, again, because we're doing something slightly different, right, than what the Harvard program is doing. But we definitely wanted to have that, I think that advocacy term, which again, we're on the side of the families, we're advocating for them. I think that's really important. But we definitely had, the agency was very much in favor of that we're advocating for families.
Thanks, Jennifer. Let's see, we're at the end of the time session, but we do have a 10-minute break. So I'm going to go ahead and pose these last couple of questions for some thoughts. But Diane was asking about, I think you all addressed this, but as far as your use of a multidisciplinary model, both of programs are utilizing a multidisciplinary model, correct? Okay. And I know we're going to have some great sessions on the multidisciplinary use like later in the day. So for the sake of time, I'm going to let that stand. And then the last question was about controlling client expectations. And I think we get that a lot in this space, right? And of course, as attorneys, we always have the obligation to sort of explain the course of representation and things. But do you all find that that's difficult, or have you put anything into practice in your programs as far as sort of addressing client expectations as you're working with them in this sort of middle ground space that it can be a little unclear, right?
We, our expectations are more in terms of trying to make people understand that we're not able to provide direct representation. So we can't actually be their lawyer in court for most of our referrals. And one approach we've taken is to make sure that the CPS workers who are referring to them to us understand that and are setting those expectations up front. So we've had a lot of conversations with social workers about the conversations they're having with people before they refer us over. And so that has been helpful. But yeah, I think that's a problem, right? Everybody needs a lawyer. No one can afford a lawyer. And so it's a hard conversation to have with people and a hard expectation to set. And something that our students, I think, struggle with, and is a good learning tool for them, and in order to and a way to have those hard conversations with clients or with non-clients in this case.
And I'll just say very briefly, outcome expectations are always a pain point in every practice. None of us can promise, okay, yes, you're going to have a lawyer for this investigation, and that's going to mean they're not going to support or substantiate the investigation. Like, of course, we cannot promise that. And then, clients will even ask us, like, do you think having a lawyer hurt me in this investigation? And, these are very hard questions to muddle through. And especially where this is a new field, I don't have the body of work yet behind me to give a client a good read on that. Like, I don't know if it hurt or it didn't hurt. This is kind of, in the very new phases where the agency, literally this week, I had a worker ask me, why did your client hire a lawyer? And I was just taken aback by the question. I was like, well, they can have a lawyer under your own policy that says they can have a lawyer. But it's, how are we going to navigate that being seen as a negative, that they have a lawyer, and that means they maybe have something more to hide, whatever that means to the agency. So I think these are the really tricky questions that summits like this and talking with each other that we hope to really work through.
Great. Well, thank you all so much for a wonderful presentation. That was some excellent information, and it is always wonderful to hear about your programs and the great work you guys are doing. So at this time, everyone, we will go ahead and take a break. We're going to break until 10 o'clock, and then we'll be back on with session 2. Thank you guys so much.